Good morning, seniors, colleagues, and friends. I am Alipak Banerjee. I work with Nishit Desai Associates, and I'm a member of Young MCIA Steering Committee. I, along with my colleague Taiko Suzuki, attorney from Nishimura and Asahi, Tokyo, and member of the Young MCIA Steering Committee, will take you through all the sessions for today. May I now invite Niti Sachdeva, Secretary General MCIA, to provide the welcome address, please.
Respected Shri Suresh Prabhuji, Justice Sikri, Mr. Lalit, Bhasin, David, Rivkin, senior advocates, friends, ladies and gentlemen, a very good morning to all of you. It is indeed my pleasure to be welcoming all of you to the third annual conference of MCIA, Institutional Arbitration. The time has come. It's our first conference in Delhi, which happens to be my hometown as well. MCIA was launched in October of 2018, and at that time, we promised that MCIA would build on its commitments, continue to improve as an institution, and never stop learning. We intend to achieve all of this with the support of the people present in this room, courts, and of course, practitioners from around the world. While MCIA has been able to accomplish a lot in these 2 years, but I would like to mention some specific significant achievements that we have had over the last 2 years. Supreme Court reposed faith in MCIA by referring a Section 11 petition of appointing an arbitrator to MCIA to appoint an arbitrator. Thereafter, the Bombay High Court transferred an ad hoc arbitration into an institutional arbitration to be managed by MCIA. And very recently, the MCIA got its first case from a contract which had an MCIA clause as a dispute resolution mechanism. What is also heartening to note is that the clause was between a Jaipur and a Chandigarh-based party, with Delhi as the seat and MCIA as the rules. We are very glad for the parties to have reposed confidence in MCIA. MCIA has conducted over 300 plus arbitrations in its premises as it commits to provide world-class arbitration facilities for doing arbitrations in India. Over the past year, we have engaged a lot with the younger members of the profession and conducted training programs across India, one of which was done yesterday itself. We are now a proud family of 500 plus young MCIA members. Another significant achievement of MCIA has been the support that it has got both from within India and outside of India. The last conference that we did in Mumbai, we have people from about 10 different jurisdictions attending, which is the same as now as well. And MCIA took upon it and did roadshows in different jurisdictions like Japan, London, Malaysia, Singapore. And we shall continue to do the same in the coming year as well. We shall not be able to achieve all of this without the support of all of you present here, and hence I would once again thank you all for believing in and supporting MCIA. Once again, welcome you all to the MCIA third annual conference. Thank you.
Thank you, Niti. We will commence today's event by the first plenary session. The speakers for the plenary session are Shri Suresh Prabhu, Honorable Union Minister of Commerce and Industry, Honorable Justice A.K. Sikri, Judge Supreme Court of India, Mr. David Rivkin, Co-Chair of International Dispute Resolution Group at Debevoise and Plimpton LLP, former President of International Bar Association and MCIA Council Member, and Dr. Lalit, Bhasin, President, the Bar Association of India, and Society of Indian Law Firms. May I please call the dignitaries on the stage to commence the plenary session. The Honorable Minister is with us very briefly, will brief the order of precedence, and may I now invite Shri Suresh Prabhu to deliver the keynote address, please.
As a Minister of Commerce and Industry, I can clearly see that India's trade volumes are rising, India's industrial activity is expanding, and India's engagement with the rest of the world also is on the rise. when we see the trade increasing, business volumes expanding obviously, underlying possibility of any business transaction, if not a dispute, a misunderstanding. There can always be an issue related to quality, delivery, terms of trade. For any reason, there is bound to be some sort of an underlying issues which will keep emerging. And this is not for the first time in history that is happening. The disputes are as old as the trade. But older times, the trade disputes were settled through war. But then later on we realized that there are better options available, so we decided to go to the courts. But then we realized that now courts are flooded with so many activities, and in India, more. So because there are so many issues keep going to the court all the time. And therefore, in the wisdom, Parliament decided to pass this arbitration law. And I think this has been a very significant improvement in terms of how do you settle the disputes and how do you make sure that this happens in a manner that is acceptable to both of them. Unfortunately, most of the arbitration, particularly of a larger magnitude and of global dimension, was never settled in India. People had to go to London, to Singapore, to many other places, and I'm very happy that we have set up a center in Mumbai, which is now becoming, as my friend was just now explaining, becoming very popular in terms of an acceptable. More and more people are getting engaged with it. So I think we really will encourage this activity to expand in India. Because if the dispute happens in India, in any case, whenever there is an agreement between the parties to the transaction and they are agreed for arbitration, they can always agree for Mumbai, agree for this. But for that to happen, we had to increase the level of this and also the quality of this arbitration center, which has happened over a period of time. So I'm very happy that now we will be creating an institution which already created, but we will be creating it better in India, which will actually deal with these arbitration issues. We, in the government, are working very aggressively on improving ease of doing business. In the next few days itself, we'll be giving our fellow Indians even a better news, because we already improved last year the ease of doing business from 132 to 100. But I'm sure this, in the next few days itself, in this week, coming week, we'll give news that there is an even better improvement. I will announce it officially in the next few days. But what contributes to the ease of doing business? There are many issues. There are very different parameters which have been decided not by us but by the World Bank. But one of the very important issues any business transaction would look at is how do you settle the dispute. And that's the most important thing. If the dispute redressal mechanism is not as robust as it should be, not as transparent as it should be, as efficient as it should be, so that it can be settled in a very speedy manner, it will never be, the business transaction itself will not take place. And therefore, as a part of our overall mission of improving ease of doing business, I think we should focus on how do you make sure that dispute redressal mechanism in India improves significantly. Whatever happens, eventually, the contractual obligations are properly met. We respect contractual obligations and we ensure that whatever is mentioned in the contract, including arbitration, is properly followed and done in a very efficient and timely manner. So to do that, we had a great need for an arbitration center like this. Will be very happy to promote it, we'll be very happy to support it, and anything that goes with that, we'll be very happy to put that entire ecosystem in place. And I'm happy that you are doing it in Mumbai, because this is my hometown, so I'm happy about it. But rightly so, because Mumbai is a commercial capital of India. Most of our business happens in India, therefore most disputes will also happen in Mumbai, because most of the business is there, and therefore it is the right place to have it there. We'll be fully supporting it, and anything that we need to do more from my government side, my ministry side, will be very happy to support it. Because this has been our constant endeavor to engage with community of professionals like yourselves and find out what more can be done by the government to keep improving this. Only recently, our Bhasin Sahab was there. We had a very interesting program in Mumbai where we were discussing this new insolvency code. And I had said at that time also that we'll be very happy to get your feedback and find out where more we need to do more, in which areas, what we need to do more. And I would be very happy to have your feedback in a way that can be fully put in motion immediately. Because otherwise what happens, we give a generic suggestion, it becomes very difficult to implement. And then we also get frustrated that we gave suggestion, nothing happened. So please give it in a way that can be implemented very quickly, and anything that we need to put in place, we'll be happy to do it. In any case, we are focusing on 12 champion sectors of services, and we want to promote them for domestic increase, but also for global footprint to be enhanced. And those 12 champion sectors of services, we have set aside 5,000 crores, so that these 5,000 crores will be the initial corpus, which will help those services to graduate into a different level. And legal service is one of them. So I think we'll be very happy to promote these activities globally. There are so many professional firms who would like to set up their office in India. I request them that we'll be very happy to do that, provided we also are, our professions are allowed to go there. Our lawyers, our chartered accountants or professionals must also be allowed to go and do their professional practice globally. This is the point that we have been making constantly. Even in WTO, we have been saying that goods are very important, merchandise is very important, and therefore we have already agreed on quite a bulk of transactions related to that. But services are as important, are probably far more important. Even globally, we'll see the service sector growing at a rate faster than merchandise sector. The services will be, services export over a period of time will be far more, and definitely it is even now incrementally it is rising at a faster rate than the merchandise. And therefore services have to be promoted. Services will make even underlying business to grow faster. But for services to grow, we must encourage the professionals to go from India to other places also. Because if you are going to deliver a service, how do you deliver a service unless a person is physically present? And therefore this is one of the key components that we have been always highlighting in all our negotiations, including RCEP, including WTO negotiations, including FTAs that we make. We have been saying that services should be an important component of a negotiation, and in that, delivery of service by a professional should be allowed by a professional to travel himself to that place where the service is rendered. And I am sure this will happen over a period of time. We are consistently following it up, but I am very happy that now we will be encouraging this particular center to offer services of a kind that will be global in standard, will be acceptable to entire global community, and constantly we should try to increase, try to improve its delivery mechanism as much as possible. So all the best to you. I really wish you all the success and all the best. I had in fact requested the organizer to start the program right on time because I always go on time. But today I have got many foreign delegations, some political meetings going on, so I was delayed, slightly sorry for that. But I'm sure you'll not put this matter to arbitration, that's why you was delayed. So I hope they don't do that. Thank you very much. Congratulations to all of you. Thank you very much.
May I now invite Mr. David Rivkin to deliver his address, please.
Thank you very much. It is a great honor to be here and to be opening the third annual conference of the MCIA. I'm also very honored to be a member of its council. I see the MCIA serving a very important role here in India to serve Indian businesses and individuals and help create a more efficient and effective arbitration mechanism, which is so important for the overall economy, as the minister was just describing. And I thought as an opening speaker, I could just speak for a few minutes about some of the advantages of institutional arbitration, which the MCIA is working on here in India. And I'll mention it in two different categories. One is that having, I know the tradition in India, the great tradition in India is ad hoc arbitration. But having an institution like the MCIA to administer cases can provide substantial benefits to the parties. I've seen that through many of my cases over the 3 decades and plus of arbitrations that I've done. I always remember one of the earliest arbitrations that I was acting as counsel in. It was an ad hoc arbitration, and the arbitrators were appointed, and we came to the first hearing. And the first order of business for the arbitrators was to set their fees. And of course, there you are sitting in front of the arbitrators for the first time, and they said, we think we're entitled to X dollars an hour. And all you could say was, no, twice X, 3 times X. That's, there was no intermediary, there was no institutional schedule to help make sure that the fee level was appropriate. I must say there have been multiple times when I have been acting as counsel in an international arbitration where having the institution as an intermediary was quite important. Of course, the institution can play a very substantial role in helping select the arbitrators where that's necessary. There's no need to go to a court as you would have with an ad hoc arbitration. But the institution knows, and particularly in international arbitrations, international disputes here in India, the MCIA or any other institution can help internationalize the pool of arbitrators and bring in people who are really appropriate for that case. Can also help advise the parties on arbitrators with particular qualities that may be needed for particular cases. But also, there are times during arbitrations when it is better for the parties to be able to respond to certain issues, not directly to the arbitrators, but through the institution itself. I use it when I sit as an arbitrator in one sense. If I'm going to appoint an associate from my firm to serve as a tribunal secretary, I want to propose that to the parties. I always do in our first procedural conference. I always explain the role that I expect the tribunal secretary to play and how it would work. I always, of course, assure them that the decision is going to be made by the tribunal and not by the tribunal secretary. But I also, after describing it, I always say don't respond now because, again, I don't want the parties to feel pressured that they have to satisfy me as chair of the panel. I say just get back to the institution. If you have any objections, let them know within the next week. If not, we'll know that there is consent. Having the institution as an intermediary for those purposes can be very useful. Just last month, I had an arbitration as counsel where the tribunal put a certain proposal to the parties about how to proceed, and in particular whether a third party could be joined. And the tribunal, to its credit, was sensitive to the fact that it didn't want to know if one party accepted it and the other party didn't, and wanted the parties to be able to answer honestly. So again, the tribunal said, don't come back to us with your answer to this proposal. Let the administrator know, and the administrator will inform the tribunal if both sides have agreed or if both sides have not agreed, but not let the tribunal know the individual positions of the parties. So there are many just practical ways in which having an institution like the MCIA involved in a case can be a substantial benefit. The other way the MCIA, I think, can play an important role here in India is to help work with parties and counsel in internationalizing procedures and making procedures more effective and more efficient. This is, of course, something that we need to do across the globe, no question. But institutions like the MCIA play a particular role. And just to give some examples of how the MCIA can, how procedure can be more institutionalized. I think it's worth just mentioning a few. The great flexibility, the great advantage of arbitration is its flexibility. It's not conducting an arbitration the way one would conduct the same case if you were in the local court, whether the court is here in India or in the United States or any place else. It's having the flexibility to create procedures that are appropriate for that particular case. I think arbitrators that automatically send out the same procedural order number one for every case before they know and understand the issues in that case are not taking advantage of that opportunity. And institutions can, again, help the parties understand that. A number of years ago, I wrote I gave a speech and then turned it into an article called The Town Elder Model, where I talked about how in the old days, if you think about arbitration a couple of thousand years ago, the arbitrators would not have said, great, thank you for asking me to settle your dispute. Here's my standard procedural order number one. I'll see you when the discovery phase begins. But the town elder would have started from a blank slate and figured out what the appropriate procedures are. Are there who might help me understand the dispute? Who might might there be appropriate documents that would prove this contention or that contention, and would build procedure up from the bottom. We need to do more of that in arbitration. And again, as I said, to use the flexibility that's available, to use preliminary issues more frequently to dispose of some issues or to take care of issues that might eliminate the entire case. In a construction arbitration, there's no need to hear all the evidence on each and every claim, no matter how big or how small, arising from the dispute. But the arbitrators can say, we're going to hear these 3 or 4 largest ones, and these that may have common issues with some of the smaller claims. The hearing would be more compact. And inevitably, in my experience, when we've done that in construction or other cases, the parties have been able to settle once they have heard the tribunal's decision on those particular issues. Or to give another example, I've had a couple of cases for a political risk insurer client where the issues of liability, the issues of compensation, the issues of whether or not the policyholder is covered by the policy can be quite complex, involving local law issues, whether certain actions did or did not constitute expropriation or whatever the policy language covered. But in several of those cases, we felt, and it turned out correctly, that even if the policyholder was correct that in theory the policy provided coverage, there was no compensation due because of one reason or another. And so in several cases, we asked the arbitrators to put aside the issue of liability for now, not conceding it, but to start just with that issue of compensation. If there is coverage, assume there's coverage, is any compensation due to the policyholder? And one advantage to arbitration, as opposed to, say, summary judgment in a court where you can't have a factual dispute, the court can only decide it if there's a pure issue of law. In these cases, the arbitrators held a one-day hearing on the factual issues relating to just that compensation issue, decided that we were correct, that even if there was coverage, no compensation was due to the policyholder, and the case was disposed of that way, rather than having what would have been a week-long or much longer hearing if we had gone into the liability issues, and then whatever that finding had been, that at the end, the same result would have been found on compensation. So it was to the advantage of the parties to do it this way. And again, I think as arbitrators, as counsel, we need to use this flexibility, and institutions like the MCIA can help educate the parties, can help push them, can help work with the arbitrators in figuring out the best procedures. The other thing that I encourage when I'm talking about how we can all make international arbitration more efficient is simply focusing on proper scheduling of the case at the beginning. And here again, institutional arbitration can have some advantage because it can encourage the arbitrators to do this. We asked the arbitrators as soon, when the hearing is scheduled at the first procedural conference, similar at the same time to schedule their deliberations that will follow that hearing, including the day immediately following the hearing, so that you know it can begin while everything is fresh. But if the arbitrators wait until the hearing itself to then find what days they have in common to meet and deliberate, it can be months before they can find a common day to do it, and the efficiency of the case is gone. So again, I think it's important for us, wherever we're doing arbitrations, here in India, anywhere else, to think about these kinds of issues, these kinds of procedures to make arbitration more efficient. As the minister was saying, international arbitration serves a very important purpose in the economy. It serves a very important purpose for our businesses, and our businesses are demanding more effective and efficient arbitration. They can't wait years to have a problem resolved. They need to find ways to have those problems resolved quickly. And the more we use our imagination and our flexibility, the better we're going to be able to serve them, both as arbitrators and as counsel. And I do think going forward, businesses are going to be selecting, as their arbitrators and their counsel, people who are thinking about ways to find creative and early solutions, even after appropriate hearings to their cases. And this is a role that I'm sure the MCIA will play here in India. And as I said, I'm very pleased to be a member of the council and to help work with it and work with all of you in improving arbitration processes wherever it takes place. Thank you again for inviting me here today.
Thank you, Mr. Rivkin, for the insightful address. May I now please request Justice Sikri to deliver the special address?
Good morning to all of you, Mr. David, Mr. Lalit Bhasin, all senior counsel and other dignitaries who have come from other countries, senior counsel from this country, and many other lawyers who are sitting here. It is indeed a pleasure to be here and to be discussing with you. Let me at the outset congratulate MCIA, although the theme is, which we are going to address, that institutional arbitration, the time has come. But what the minister spoke, I think it also says time for MCIA has also come. You have arrived. And that is something really good insofar as India is concerned. As I have seen the program, and there are many technical sessions on various aspects, but since the focus and the theme of the conference today is institutional arbitration and the time has come, I'll try to say something on that and focus on that. Of course, Mr. David has spoken about it, and even Mr. Prabhu also mentioned about the institutional arbitration and the way he said that why MCIA is becoming important and the government is even ready to extend the support. Let us start with some basic facts, which are, there and nobody can shy away. One is that we have entered into now it's 25, 26 years, era of globalization and liberalization. And in that process, of course, India has always been trying to get more and more FDI, more and more collaborations with the industry in other countries. And as the minister also said, that we are thinking in terms of ease of doing business. So if that has to happen, we have to have a proper environment, a friendly environment, which includes arbitration as well. Why I say it includes arbitration, because when we are talking of collaborations and all these aspects and the business houses who are coming together and having alliances, etc., inevitable fallout is that disputes are bound to arise. We can't help it. But at the same time, if these disputes arise, it is also in the interest of business community that they are settled as early as possible. And it is always conceived that arbitration is the best mode of settling these disputes. Not only confidentiality is maintained, autonomy is maintained, and but another very important factor is that you can go to arbitration, but at the same time, the relationship, the business relationship may also continue simultaneously. So therefore, this is the other aspect we have to see. And another thing is that with exponential growth in the international trade, today disputes are having international ramifications. We have more, and they are going to lead to international arbitration as well. And all these disputes are becoming very, very complex, as I'll refer to that a later stage. Now, in this whole scenario, what is the role of institution arbitration? I think we need not even debate on that. It is what in our, this one term is that, or this principle of res ispa luceta, that applies, that things speak for themselves. We don't have even to find any evidence to support it. Our Arbitration Act, which has been amended recently, it has given great emphasis on institutional arbitration, which was not there earlier. That itself shows the even legislative or parliamentary wisdom in giving importance to international arbitration, the institutional arbitration. And that is one thing. Other thing is, in Indian scenario, if we are very frank and we should admit it, we still are struggling to have our feet on the ground. The people that, whereas in other countries, SIAC, LCIA, ICC and all that, they have done wonders, and SIAC is an example in last 15 years, the way they have come up. We are nowhere around. Whenever there is a discussion on whether seat of arbitration can be India, or so far we are lacking in it. And the main reason is, if I may say so, or what David also mentioned, that we are still having ad hoc arbitration approach. At this juncture, I feel, and I am of firm conviction, and I keep telling my fellow judges in the Supreme Court also who are dealing with applications under Section 11, that change the shake off this mindset. And when Section 11 application comes, instead of appointing an individual as arbitrator or even constituting arbitral tribunal, why can't you refer it to some institution and let the institution take care? And even if you want to appoint somebody as arbitrator, as Niti also said, let it be under the aegis of MCIA or some other institution. And why not you give it to the institution? There are many, many advantages of that. And one thing which I am emphasizing at this stage is that in order to have recognition in world community, it is imperative today that we have to have institutional arbitration. And that would be one thing which would resolve so many problems insofar as India is concerned. We know, actually, we have to resolve disputes, as I said, in a speedy manner. It should be cost effective as well. And we struggle many times at the threshold, at the level of constitution of arbitral tribunal itself. And Section 11 application, if the parties are not able to decide, that application goes to the court. The way it is sometimes, although many judgments have been given now as per which the process is eased, but still we find that most of the time the opposing party will come out with some kind of objections, etc., and it will take time to decide Section 11 application itself. This can be taken care of. The procedure which the ad hoc arbitrator would follow, again, it depends on every arbitrator what kind of procedure it is going to he is going to follow or she is going to follow. It can be taken care of if we have the institutional arbitration. We know, although Arbitration Act has now come out with the fee schedule, but still it gives a leverage that with the consent of the parties, the arbitrator can fix some other fee, and normally a retired Supreme Court judge or High Court Chief Justice, when he fixes the fee and he tells both the parties that I'm going to charge, so out of sheer respect or maybe for some other reasons, the parties would not say anything and would agree to that. But that would not happen if it is international, it's an institutional arbitration, because institutional arbitration fee schedule is there and the arbitrator has to follow that. So going by Indian conditions, I would say, and going by the demands of the international community, institutional arbitration is really, really important. And you see that one thing I may say here, that in order to have proper reforms, we need to focus on 3 areas. Number one, and it's anywhere, there should be a robust statutory regime. It should be international compliant, which it is today, thankfully, because of so many amendments, etc., which have occurred in our Act earlier, and some of the problems which we were facing with 1996 Act and the judgments which were given by the Supreme Court, which were treated as setback to the, as far as environment of arbitration is concerned, that has been taken care of. And if you see on that basis, in last 4 or 5 years, the Supreme Court has given judgments which are really creating a sort of a culture, that arbitration culture in India is now developing, and that is coming up. But then, at the same time, very important aspect is, on which we were discussing now, that arbitration proceedings are also to be conducted in a proper manner. And that can be achieved by institutional arbitration. Why I say so, in addition to, I would not be touching upon so many aspects, but would be only highlighting 2 aspects. One, I was going to say it, what was conceived by David and was told by him that in that conference in Singapore on experimenting with blank sheets, if you remember. And David has spoken there, and he has already, today also he has dealt with that, is about that town elder approach. You see, what happens, normally it is seen, why that is necessary. We have this tendency today in any arbitration, not only in India, elsewhere as well, that the pleadings are, very, very lengthy. They may run into hundreds of pages. When pleadings are lengthy and so many issues are raised, whether they may arise in fact or not, but just out of, as a, in a way, say precautionary measure, both the parties want. So it leads to framing of so many issues which may not be required. Then another thing which is seen is that the arbitrators, normally the arbitral tribunal, would not be controlling the proceedings. Today the fact remains, and that's the harsh reality, that it is lawyers who control the proceedings, and the role of arbitrator comes only at the end when the arguments are to be heard and the award is to be given. Unlike in court, where the court tries to control the proceedings from very beginning. Here, how the proceedings are to be conducted, what could be the pleadings, how the issues are to be settled, how the discovery is to be made, what are the witnesses to be examined, cross-examined, etc. The counsel for the parties would be dealing with that. But there has to be some change in that. And that change can be, my focus is to tell that this can be only if it is institutional arbitration, not ad hoc arbitration. And one thing which here I come is that how this town elder approach becomes important. Mr. David has explained what this town elder approach is. Here, if I may summarize it again, is that the arbitrator plays an active role from very beginning. The claimant would be called upon to give file its detailed statement of claim. And on the very first hearing, as I have seen your paper and heard you also in Singapore, on the very first hearing, the arbitrator would not sit like a mute spectator. It would tell the other side also you come prepared with all the issues. So all those issues would be discussed, said bare, and there itself it would be settled. Yes, arbitrator will have to do some extra work, but here it would be settled that what kind of disputes are there and how the parties would proceed. In that sense, from beginning itself, arbitrator is going to have some control over the proceedings when he make the parties agree the manner in which it is to be done. And very important thing, which David has said in his paper, and I have read that, is that in the very first meeting, the arbitrator would also ask the party to explain their business needs. If you remember, David, that is what you have emphasized. And the type of decision they need, and the time by which they need the decision. See, what I feel and what I read in it is the mediation techniques. Because when the two parties are there, they sit together on the first hearing, and they are even discussing their business needs, they would understand that whether it is necessary for us to prolong this dispute, or whether it is necessary for us to have some kind of solution which may be acceptable to both the parties. Of course, I'm not saying that mediation is taking place at that stage, but this is that technique which is borrowed by the arbitrator even in the conducting of arbitration proceedings. And what is there is said that the kind of arguments they would be producing, the testimonies and documents, the submission that would be necessary, all that is discussed at the threshold before the arbitration proceeding start. So in this manner, the arbitrator plays a very, very, active role from very beginning. And this is, if I may say so, the two other very renowned arbitrators. One is, apart from David, whose town elder approach I have said, Michael Schneider. He has suggested, he calls it as a commissioner model, like where the court appoint commissioner to go and have a spot, inspection and to check the, so it is kind of inquisitional procedure and not totally adversarial procedure, and it is a mix of the two. And it is, and there may be another, Carol Nerin, QC. He has almost all these approaches are, as I have understood, almost the same, but he calls it as a diagnostic consultant approach. That some kind of diagnostic would be taken and it would be without prejudice. And again, I would say that this is a part of what you borrow from mediation. In mediation proceedings, we have, when the matter goes to mediator, and it is called early neutral evaluation, E&E, that the mediator will tell the parties that you go there, this is the an outsider, an impartial person who will evaluate the merits of or demerits of the cases and would give his opinion, which is not binding, which is without prejudice. But then it is the reality with which the two parties are confronted with. A particular person or party may be saying that, yes, I have huge claims against the other party, but then I am shown the reality. Then I may at that stage come out and the scope of arbitration proceedings and what has to be ultimately conducted would get reduced. So it not only results in speedy disposal of the case and award coming, but much of the areas which were not even required, they all are wiped out in the process. So, but then question arises is, if these kinds of bold approaches are to be adopted, it can't happen in ad hoc arbitration. It can happen only in institutional arbitration because, and for the reason that as far as institution is concerned, it can provide in its rules such an approach. And once that is in the rule, then the arbitrator or arbitral tribunal is armed with that kind of powers to carry on this, and tomorrow nobody can say that, look, what arbitrator or arbitral tribunal had done was not within his powers, and therefore it should not have been done. So therefore, this approach, which may be necessary in today's world to conduct the arbitration proceedings in a speedier manner, again, it can be done if the institutional arbitration is there, and that justifies the existence of institutional arbitration vis-a-vis ad hoc arbitration. Other thing which I would like to highlight at this stage is that another emerging trend which is taking place and which is becoming very prevalent, that is emergency arbitration. Need is felt today that we have to have emergency arbitration. And it's for simple reason that if one goes to, yes, like in our, and that may be the position in every statute, in our Arbitration and Conciliation Act, there is Section 9, person can go to court for interim measure, and Section 17, where the arbitral tribunal can pass an order as far as interim measures are concerned. Fortunately, our act is amended and the arbitral tribunal is given almost the same powers which the court has under Section 9. But then, going to the court and asking for such interim measure, it takes time. As far as tribunal is concerned, unless the tribunal is constituted, it cannot look into it. So therefore, need for emergency arbitration, which is being felt at international level. But today, although we talking about India, and then I will come to other institutions, in other countries as well. Although many amendments took place in 2015 and then 17 also, and Law Commission of India had recommended that the definition of arbitral tribunal under Section 2D be changed to include power to carry on with the international, emergency arbitration as well. This amendment has not been carried out. Now, in the absence of that, and when emergency arbitration is the need of the hour, how to do it? Again, we go back to institutional arbitration, where there is a provision. MCIA has the provision, I have seen. Likewise, all SIAC has provision, ICC, all these institutions have the provision. So even the emergency arbitration, if we have to, of course, in India we are now facing a different kind of problem, which is this, that even if the institution has the provision and the emergency arbitration takes place and emergency arbitrator pass the award or the order, then how it is to be implemented, what is the legal effect of that? That is being grappled with. That is not the, there's one judgment of Delhi High Court, one judgment of Bombay High Court on this, but I'm not going into those issues. In the absence of any statutory power, both the courts have said that, okay, even if that cannot be, because today the order passed under Section 17 is also treated as award after the amendment. So both the courts decided it. Of course, there are other problems. We are not discussing that in detail, but the court said that, look, in terms of that order of the emergency arbitrator, court will pass an order so that it becomes a binding order. But that is the route which is taken. But for the purpose of institutional arbitration, what I am highlighting is that even in order to have emergency arbitration, we have to have institutional arbitration. So therefore, it's a very apt occasion and a moment to say that, yes, institutional arbitration time has come for various reasons. With this, I congratulate MCIA once again in taking lead and becoming first international arbitration center in India. I hope that you are going to go a long way, and I'm hopeful that they are going to be in various technical sessions, very intense and fruitful discussion, and whatever is the outcome, please share it with me also. Thank you very much.
Thank you, Justice Sikri, for such a thought-provoking address. May I now request Dr. Lalit Bhasin to deliver the closing remarks.
Honorable Justice A.K. Sikri, Mr. David Rivkin, Niti Sachdeva, so many friends from overseas, Mr. Christopher Law, Mr. Nicholas Peacock, and friends from India, Mr. Amarjit Singh Chandeok, Mr. Amit Kapoor, Mr. Nakul Diwan, Mr. Nick Shetty, Mr. Vikram Nankani, Vyapak Desai. It's indeed very gratifying to see on a Saturday morning in Delhi to have a packed house, and when it also happens to be a very auspicious occasion for the ladies here and for the men, because today is what is called the Karwa Chauth. Karwa Chauth is a day of fasting for wives to wish a long life for their husband, you see. And husbands don't keep that fast, but some of us, in sympathy and in tune with the spirit of great affection and love, we do that. So it's a very auspicious day to have this packed house, despite it being a very important function. The Honorable Minister, he spoke about the need for institutional arbitration. I must share with you that whatever he says, he's very sincere about it. And when he said that he would welcome foreign lawyers to come here and also Indian lawyers to go overseas, he really meant it. But now how that is to be implemented, that is the question, big question. That question was answered by the Honorable Supreme Court in a judgment delivered earlier this year, that foreign lawyers can come to India provided there is an amendment in law, because the Advocates Act only allows Indian citizens to practice law in India. Therefore, the ball is actually in the court of the government now. I must share with you, and I say with daring certainty, as the President of the Bar Association of India and the Society of Indian Law Firms, that the Indian legal profession is not standing in the way of the foreign lawyers coming to India. We welcome that, and we had conveyed this to the government right from the year 2014, that now this is an era, this is a period of, as Nishit Desai called it, co-opetition. It is cooperation and competition. So we would welcome a healthy competition from our foreign friends. But the Supreme Court says that no, they cannot practice till the act is amended. Therefore, the first thing to be done by the government is to amend the law, which they can do. But I don't think you see that with the elections coming in 2019, this will be an area of any top priority, either for the government or for the legislature. But he did speak about the need to have institutions. And I must convey my deep gratitude to MCIA for setting up really at least one institute of excellence so far as arbitration is concerned. We do not have anything else in India. I can say that again with some certainty. And the need to have such institutions is highlighted, as Honorable Justice Sikri said, that ad hoc arbitration is not the answer. Why arbitration has failed to be an effective alternate dispute resolution mechanism is that there is ad hoc arbitration and there are no institutions. So MCIA is a shining example of what can be done, what can be achieved if we have similar institutions. Mr. David Rivkin very rightly spoke about internationalizing the procedures. I think that is very relevant, particularly in the context of the international disputes. And I would share with you, and I again compliment MCIA for entering into arrangements with the Chartered Institute of Arbitrators. It is reflected in their annual report also, which is in your conference bag, to train
the arbitrators and the mediators. And that is where the Chartered Institute of Arbitrators, of which again I happen to be the chair, my colleague Vyapak Desai is also here. We do try to render some assistance in that regard, and we have entered into a protocol with the MCIA. And only in Dubai very recently, last week, there was a move which is now like a regulation in place for the Chartered Institute of Arbitrators, that they must have the same set of rules and regulations for the coaching programs, the training programs at the international level. So there will not be any separate training program for India or for the US or for Malaysia. There would be a uniform system of coaching and training all across the globe, wherever the Chartered Institute of Arbitrators is. And that is, I think, the need of the hour, and that is where we need to go, as very rightly pointed out by my friend David Rivkin. So I thank all the worthy speakers and also the minister in absentia for really sharing their very valuable views with us. Thank you very much. Thank you.
Thank you, Dr. Bhasin. Since we started late, we will not be breaking for tea. Tea will be served inside the room, and we are doing this to keep to the timelines. I will now request Vyapak Desai, Head International Litigation and Dispute Resolution Practice, Nishit Desai Associates, and MCIA Council member, to come on the stage and give the opening remarks. Thank you.
Good morning, friends. I don't think I need to say anything except what we just did. The theme is institutional arbitration, and why institutional arbitration is the only way to go about it. I think the first and the foremost is timeliness. And you just saw that if you are part of an institution like MCIA, and if you are late, then you don't even get a coffee, but you have to continue working to make sure that you don't delay any of the sessions, even in a conference like this. I think this shows what you get when you subscribe to or you attach with an institution. And there are many such institutions, but definitely MCIA comes in the forefront. So I don't think there is anything more for me to say for the opening remarks, but maybe 2 more minutes. I think when we as council members were discussing as to what do we do this year as part of the annual conference, and it was very surprising that the topic which is possibly not debated world over is still a topic to debate as to whether ad hoc arbitration is better or institutional arbitration is better. But we really felt that rightly so, India still needs this debate to ingrain themselves into what something which is foolproof, something which has delivered results world over, and I don't think there is any other option for India as well but to subscribe to institutional arbitration. So with that thought process, we said, let's go with it. And to our advantage and to our thought process, even government possibly is also thinking in the very, very same lines. I think after path-breaking amendments in 2015, it is for the first time possibly even for a country like India, where we are going with another set of amendments in less than 2-3 years. And it is based on the topic of institutionalization of arbitration, which was the expert committee set up based on which the new amendments are, being proposed. So that shows the commitment, that shows the focus, that shows that India has really upped their game to make sure that this is something which will stay here and will make sure that the arbitration as a process, as an alternate dispute resolution system works. So with that, we have sessions which are very, very relevant for the theme. Of course, the first session we will talk about the recent amendments. We have 2 recent amendments to, so to say, 2015, of course, and then the proposed amendments which are already passed by the Lok Sabha and pending Rajya Sabha approvals. So there are a lot of topics to, talk about. The second topic again was something which we thought to say that it's a myth for a specific reason, and I'm sure as the debate continues even on that topic, we'll come with some solid proofs as to which way even the costs and delay work from an ad hoc versus institutional perspective. The third topic is a little more crucial, because as we move along in this alternate dispute resolution route, I think the arbitration is as good as your arbitrators, and party autonomy is the key. So how do you solve the problem of party autonomy versus conflicts, and how do you get over the issues which people talk about as to what is stopping the arbitration not working in India? Then, of course, we just can't look at our past. We will look at our future as well, and what is coming our way in next 5 years, 10 years, 20 years, 50 years. We'll see what session number 4 has in their kitty so far as the future of arbitration is concerned, and what is something which all of us in this room have to focus. And then, of course, the last session, the most important possibly, so that people stay back, though it's a Saturday. I think, as Mr. Bhasin said, I think anyways, there is no food till some time in the evening. So before that, at least we'll finish the session, which is again very, very interesting one. I think the world was surprised or maybe shocked to see that first time in a statute in a country like India, there is a subscribed and a prescribed time limit to finish arbitration. Now, every institution, every country says, okay, the average time is 18 months and we finish all the arbitration. And suddenly when India came up with this idea of 18 months, 12 plus 6, and everyone said, oh, how can you do that? And we said, okay, you said we delay a lot, but then, okay, we are giving it to you in 18 months. So again, that became a huge debate. And then 2018 is trying to address some of those issues as well. So I think that is going to be, in my view, one of the most interesting panel as well. So please stay back for that. With that, I think there is a lot to come. There is an excellent panel, excellent speakers to take through the day, and I'm sure we'll take something much more than what we expect in a conference on a Saturday in Delhi. So I welcome you all. With that, I'll invite the first panel to, or maybe Alipak to invite the first panel on the stage. And again, I think last but not the least, we again thank the transcribers here just to show how the efficiency works. And this is the 3rd year in a row where the whole conference is getting transcribed real time. And this is how we show that if you do an arbitration in a manner, then of course you choose your words. And when you choose your words, you are obviously more efficient rather than rattling away a lot of things which are possibly not recorded. So with that very, very short introduction to the panels and the theme, I would invite Alipak to now start the session right on time as we promise. Thank you.